This is the fourth Sunday of the month, so we have our second collection, and this is going to benefit the UU community of El Paso, Texas, which is doing a lot with migrants on the border right now. So we're doing it for their migrant ministry, not for the church. But your first collection supports this church. So this is the fourth Sunday, and we always have a second collection as well. I have a few here. Ginger Ryan, our board president, would like us to know the Board of Trustees has set the date for the annual meeting for April 30th, 2023. Please mark this important date on your calendar and plan to attend. If you're interested in a board position, contact Joyce Carpenter. There she is. Do another dance. This is our wonderful Joyce. She is our nominating committee. And if you don't approach her, she might approach you. Don't run away. Be kind to Joyce. Are there other announcements back there? I looked, but there might be. Oh, yes, today at 1, right? The Freethinkers meet to do what freethinkers do. Yes, and loudly together. I haven't seen it come to blows, but it can get heated. It's a lot of fun. I have an announcement. We have something called Our Whole Lives, which is a curriculum that teaches not just about sexuality, although it is about that, but just as a rare denomination that values the body, doesn't believe in original sin. It's a course that looks at the body and our relationship to it and how it fits in our life story. There is training for that in early March, and it is extremely rare to have it nearby. I realized that I could actually do it. We're going to I need another person to come with me from here, or I will find someone from Borderlands, and they will do it. Oh, you were interested? Cool. Okay. I was involved in that in Oregon. Right. 10 years ago. Yeah, it is wonderful. It's for all ages, and we're having training for all ages. A few years ago, I know that we sent people to train in high school, but we figure adult is what we have, is what we can offer the community. And sneakily, people who train in adult and do adult courses, it leads to others. It's a gateway thing to others doing younger children as well, learning the process. So, okay. All right. And now that we've heard all the news that's fit to announce, I'd like to welcome everyone to Sky Island Unitarian Universalist Church. I'm Tina Squire, and I will be your facilitator this morning. I'll be facilitating for Wallace Hoggatt, a.k.a. Wally, who will be speaking on the topic of the rules of construction. I think that has something to do with rules about how to interpret laws. I only know that because Wally told me that. But he'll have to speak for himself to make that clearer. So welcome, everyone. All of you actually present in the sanctuary, and those of you who are quite present, courtesy of Zoom. We are a church of the open mind, the loving heart, and the helping hands. In our congregation, we do not share a common set of beliefs, but we share a common intention to strengthen the powers of love, justice, and peace within us, between us, and in relationship with the web of all existence, of which we are a part. Whatever your race, whatever your gender, wherever you were born or how long ago, whatever your job, your rate of pay, how many times you've been married, however long or short time you spent in school. Can you tell Wally wrote this? Whoever you love and whoever it is who loves you, and even if you'd rather be somewhere other than here, you are welcome. Our chalice lighting comes from a passage of The Irony of American History by Reinhold Niebuhr. It was published in 1952. And as my own aside, this hung on the walls of the church I grew up in. It's one of my favorite readings. Nothing that is worth doing can be achieved in our lifetime. Therefore, we must be saved by hope. Nothing which is true or beautiful or good makes complete sense in any immediate context of history. Therefore, we must be saved by faith. No virtuous act is quite as virtuous from the standpoint of our friend or foe as it is from our standpoint. Therefore, we must be saved by the final form of love, which is forgiveness. We are a covenantal community. That means we come together because we want to, and we commit to each other. We support each other when times are bad, and we rejoice together when times are good. So here are the joys and sorrows that have been submitted to be read out loud. Are there any more behind you, Roland? And I didn't check on Zoom. I don't see anything in the chat. Okay. I have one from Wally. His wife Dottie's brother-in-law Michael, who's married to her sister Beverly, is gravely ill and not expected to live out the day. Oh, Gary. Gary says his dental implant fell out. Gary, that can happen? His implant fell out. So he's bummed, yeah. And his nephew Jose was fired because he did not come to work when he had COVID. So please think of Dottie, her sister Beverly, Michael, obviously Wally, Jose, and Gary. And I will put stones in for each of those, but also for things that are joys or heavy on our hearts that have not been spoken, but are here present because we are in this community together.
Our reading today is something sent to me by my friend Archie the Cockroach, and I know that I haven't shared too much from Archie or from Mehitable the alley cat, but I am aware that there are people here who have heard this introduction to Archie's stuff before. You could probably recite this with me by memory, but there are a few people who are here who may not be familiar with Archie and Mehitable, so let me give you a few words about them. Archie used to be a free verse poet, but he died, and then he was reincarnated as a cockroach. Mehitable is an alley cat who claims that she was once Cleopatra, but she has kind of an uncertain grasp of the relevant facts, and so that's open to doubt. Don Marquis, and that is the way he pronounced his name, Don Marquis, not Marquis. Don Marquis was a New York newspaper writer, columnist, and poet during the early decades of the 20th century. He was the one who created Archie and Mehitable back in 1916. And for about 20 years after that, Marquis published what he said were Archie's poems, which Archie supposedly created by hurling himself against the keys of Marquis's newspaper office typewriter, letter after letter after letter. Remember, he's a cockroach. Small wonder that the poems lack punctuation and capital letters, because those would require extra keystrokes. Archie said that expression was the need of his soul, and so to help Marquis fill out his newspaper columns, Archie produced a steady stream of poems about himself, about Mehitable, and about other denizens of Shinbone Alley in New York City. Marquis used Archie's poems to comment on the issues of the day and the foibles of the human race. Marquis stopped publishing new Archie and Mehitable poems in the mid-1930s after he suffered a couple of very serious strokes, and he died 3 days before New Year's Day in 1938. So for about 80 years, the voices of Archie and Mehitable were silenced. But about 10 years ago, I thought we needed them back, so I resurrected them for the 21st century. Now, a note for all of you who are interested in the legal aspects of this: the characters of Archie and Mehitable are in the public domain, the two characters, not some of the later poems. Those are still under copyright, but the characters are in the public domain. So I have legal protection against a claim of copyright infringement that might be brought by Marquis's heirs. But that might not protect me against the wrath of the ghost of Don Marquis himself. So that's why all my pieces that I write in the voice of Archie bear the subtitle, "With Apologies to the Memory of Don Marquis." Decades ago, Archie addressed Don Marquis as boss, and that's how he refers to me now. He sends me his stuff by email, and the return address is archie@shinbone.com. Now, a note about this particular piece: only rarely do I suggest topics or issues to Archie and Mehitable. I usually just wait to see if I get something, and I either use it or I don't. But this time I asked for some help. I knew that I'd be speaking today on the 50th anniversary of the Supreme Court decision in Roe versus Wade, the decision recognizing a right to reproductive freedom, a right, by the way, that was taken away by the Supreme Court in the Dobbs decision last June. And so to help me with this rather heavy topic, I asked Archie for some comments from him and Mehitable. What I received back had no title, so I gave it one. I call it, "Why Mehitable Thinks Everybody Should Skip Today's Sermon and Go Home Early." With apologies to the memory of Don Marquis. Well, boss, I had a notable lack of success in getting help from Mehitable. She was not impressed with your sermon title, or your material, or your intentions, noble though you think they are. She was not carried away with enthusiasm for another lecture about Roe v. Wade or the Dobbs case from yet another male specimen who thinks his gender grants him carte blanche to talk about anything and everything, but especially things about which he himself knows nothing. She said, "Archie, I'll bet your boss doesn't have to sleep out all night in the cold and damp amidst all the disease-carrying insects. Sorry, Archie, but you know your fellow bugs aren't the cleanest of animals. And I'll bet your boss doesn't have to wait for his supper in the alley behind the Mermaid Oyster Bar in the hopes that the night manager will chuck out some overcooked halibut or a little slightly green clam chowder. And I sincerely doubt your boss could have sympathy for an old alley cat who, well, I admit, had seen some better days, but who is still whisker for whisker way above average for her breed, and who now is regularly clawed by some tomcat she took up with briefly, and who now thinks he owns her, and who loudly questions the natural origin of the litter of offspring brought into the world through his active participation. Archie, she said, Unless your Mr. Boss Guy has been where I've been, or will be where I'm likely to be this time next year, I just don't want to hear a word out of him. It would be as if some cockroach tried to write poems from the point of view of an alley cat. Or worse yet, as if some human started masquerading as a cockroach who then pretended to write poems while posing as an alley cat. You know, she said, if you aren't a member of the species, keep your dim-witted comments to yourself. Well, boss, I hope you don't take Mehitable's rejection too hard. After all, she has the same reaction to any bloviating ignoramus, not just you. Best wishes from a fellow windbag, Archie. Gee, thanks, guys. My title is Rules of Construction. And that has nothing to do with building houses or designing physical structures, but it has a lot to do with designing legal structures. The word construction in this phrase, rules of construction, comes from the verb to construe, that is, to interpret. And in the legal and judicial world, a rule of construction is a rule of interpretation. And to put it another way, a rule of construction is a rule about how to read other rules. Now, rules of construction can be chosen explicitly or expressly by whoever wrote the law in the first place, or they can be imposed, rules of construction that is, on a legal text later on, because some kind of rule of construction is necessary for any body of law. You know, it used to be in Arizona and a lot of other places besides that criminal laws had to be strictly construed. And there were loads and loads of cases that said that. Strictly construed, hemmed in with words confined to their exact, literal, precise meanings. But when Arizona got around to revamping its criminal code back in the 1970s, the legislature added a provision eliminating that rule of construction and said the general rule that a penal statute, meaning a criminal statute, is to be strictly construed does not apply, and they substituted another rule of construction, which is fine. That's what they're entitled to do. Now, whether we are trying to interpret some criminal code or the Constitution of the state of Ohio or the Constitution of the United States, the applicable rule or rules of construction can dictate the result. But how do you interpret a provision that is vague and unclear and may very well have been left vague and unclear on purpose? 50 years ago today, the U.S. Supreme Court decided Roe versus Wade. That is the 1973 decision holding that women in America had the constitutional right to reproductive freedom, the right to terminate a pregnancy by abortion, of course, depending on the particular stage of the pregnancy. Now, attacks on Roe started pretty much from the moment it was decided. And opponents of Roe were hoping for success in 1992, a little bit more than 19 years after Roe versus Wade was decided in the first place. They were hoping for success in 1992 with a case called Planned Parenthood versus Casey. But they were disappointed that year. The Supreme Court in Casey in 1992 modified Roe a little bit around the edges, but basically kept the core holding of Roe intact. After Casey, women in America still had the constitutional right to control their own reproductive destinies, at least for another 30 years. Well, goodbye to all that. In June of last year, the Supreme Court issued the opinion in Dobbs versus Jackson Women's Health Organization, which overruled both Roe and Casey. Now, I started law school in 1976. At that time, the battle lines in the abortion law wars had been drawn. And they had been drawn from the moment that Roe was decided, actually even a little bit before that, because before the U.S. Supreme Court could decide Roe versus Wade, there were cases going up the ladder, including Roe itself. But the battle lines may have been drawn by the time I went to law school in the fall of 1976, but not all of the incoming law students had chosen up sides. There were many bright and impressionable young law students, and some who were maybe not quite so young, having committed themselves to a career before that, but many bright and impressionable law students who were open to being persuaded one way or the other. Now, you may have heard of the Federalist Society. The Federalist Society is a conservative/libertarian legal organization. It did not exist yet in 1976. It came into existence in the early 1980s. But there was a rightward impulse among many law students, law professors, lawyers, and other people involved in the legal and judicial professions. And later, that impulse did find a home in the Federalist Society. Now, that rightward impulse got a big boost from the decision in Roe. Why? Well, because it provided a target. Few things help a movement gather adherents quite like something to hate, quite like something to ridicule. And frankly, to be very blunt about it, the opinion in Roe was easy to ridicule. It really was. Just as an example of judicial craft, it was a dreadfully sloppy piece of work. And its main problem, one of many problems, but I think its main problem was that from the very outset, it confused why it was doing what it was doing. It didn't seem to understand what it was doing or why. The Roe opinion, the decision itself, granted reproductive rights to women based on a right of privacy that the court said could be applied against the states by virtue of the 14th Amendment's Due Process Clause. And that says, as many of you here know, no state shall deprive any person of life, liberty, or property without due process of law. But you know, when you're talking about a person's control over her own body, the issue isn't really privacy, the issue is autonomy. Autonomy and privacy may and they often do go together, but they aren't exactly the same thing. You might remember, some of us here who are a bit old enough to remember this back in the 1970s, you might remember seeing some men in the 1970s and even afterwards sporting a lapel pin, and I wanted to find an image of that. I was unsuccessful in finding the original image. There were some knockoffs later that were done, not quite the same thing. But the wearer of this lapel pin that I have in mind proudly advised the world that he had had a vasectomy, okay? Now, clearly, the wearer of that pin was glad to have had the right to bodily autonomy, to decide what he wanted to do with himself. But on the other hand, that person who was wearing that had absolutely no interest in keeping that information private. As a matter of fact, privacy was not the point. It was the opposite of the point. That person, I guess, was advertising. Now, the decision in Roe was so badly reasoned that you didn't need to be a right-winger to have problems with it. And there were a number of young and serious law students in the 1970s, and I assume later on too, who became convinced that there couldn't really be a constitutional right to reproductive autonomy, not if this decision was the best anybody could come up with. How do I know that? How do I know that there were young and serious law students who were convinced that this is not, they can't be a constitutional right because this decision is so bad? Well, I know it because I was one of those. And that was my opinion. And it was only after I got my law degree, after I had thought about it for quite some time, that I realized that there really is support in the Constitution for the right of women to control their own bodies. And yes, it is in the 14th Amendment. It's just not in the Due Process Clause. The due process analysis doesn't make any sense. But the equal protection argument does make sense and does make an awful lot of sense. And here again, many know the language I'm going to quote, the Equal Protection Clause. No state shall deny to any person within its jurisdiction the equal protection of the laws. Now, there's no way that we in America, or anywhere else for that matter, can have anything even approaching gender equality in modern social or political or economic life unless women are allowed to control their own reproductive lives, in the same way that those pin-wearing males can control their own reproductive lives. Now, the justices of the U.S. Supreme Court who remain on the court and who still favor the right to reproductive autonomy seem to have moved away from the right of privacy analysis closer to something that looks like equal protection analysis. But the problem is, by the time that movement away from due process and towards equal protection, by the time that really started to happen, it was too late. Because the issue of a woman's right to bodily autonomy was for decades fixed by a discussion using Roe's language and using Roe's legal framework. Now, if Roe had its conceptual problems, and it did, the Dobbs decision, the one last June that overruled Roe and Casey, has even worse problems of its own. And chiefly, its problem that leads it to the outcome that it was led to concerns its choice of a governing rule of construction. Now, it seems to rely on two different but still commonly argued together rules of construction. And pardon me for throwing a couple of buzzwords at you, but textualism and originalism are the two words I'm going to throw out in the middle of the floor here. These are rules of construction about constitutional provisions that are often championed by conservative legal scholars. They aren't exactly the same thing. Sometimes they conflict with each other. But textualism embodies the idea that when you're interpreting and applying what a constitutional provision says, well, we have to be guided by what the text actually says, hence the name textualism. You know, as far as it goes, there's nothing wrong with that. It makes sense. Textualism goes astray when it is extended to the absence of a text, and people will do that. That is, when textualism says that if a right isn't actually put into the Constitution, it can't exist. There are people who argue like that, and some of them are on the U.S. Supreme Court. The problem with that idea, when you've extended textualism from what the text says into interpreting the absence of any text in the text itself, when you're talking about rights, Well, there is something that refutes this explanation of textualism. It's in the Constitution itself. It's in the text. It's in the text that refutes textualism. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. That's the Ninth Amendment to the U.S. Constitution. That's in the text of the Constitution. Now, that's textualism. Originalism is a term that has kind of shifted in meaning since it started to be talked about in the early 1970s. Initially, originalism was the idea that we have to interpret and apply the words of the Constitution according to the original intent of the authors of those words. So figure out what they meant in 1787 when the Constitution was written, or in 1791 when the Bill of Rights was written, or in 1868 when the 14th Amendment was written. And if you can do that, that will tell us how to apply those provisions of the Constitution in contemporary America. Now, that was the original attempt at originalism. Originalism later had to shift ground because critics pointed out that when you write a set of laws, that doesn't make what you've written become law. There's got to be ratification or passage by some body. And so originalists then tried to figure out, okay, well, I guess we can't look at what the original intent was. Let's look at the original understanding by the people who ratified these things. Except you can't really know what those people thought about what due process of law is all about, or you can't really know what kinds of punishment are cruel and unusual and therefore prohibited. And you can't really know what they thought about which actions by Congress will or will not establish a religion to be forbidden under the First Amendment. But what's even more damaging to the whole enterprise of originalism is that there is absolutely zero evidence that the founders or the ratifiers originally intended that later generations of Americans would be bound by whatever they originally thought or intended or understood. You know, there's a good book on originalism that just came out this past year. It's called Worse Than Nothing by a legal scholar named Erwin Chemerinsky. And that points out a number of the flaws of originalism, including those that I mentioned this morning. Now, Chemerinsky doesn't pretend that his basic criticisms of originalism are original with him. They're not. I mean, a lot of people have talked about him. He just put it together in a very nicely done book. And I recommend the book because it's accessible to any intelligent person. You don't have to be a legal scholar to appreciate it. And there's another reason that I plug Chemerinsky, and that is because for many years I have heard him lecture live to the statewide judicial conference on updates in constitutional law, and Chemerinsky has this ability to talk for more than an hour without a script, without notes. And he's able to speak in grammatically correct, well-organized sentences and paragraphs, all the while correctly giving the citations to the cases and the holdings of those cases. Now I need a script to talk to you for 20 minutes. Now, the Dobbs decision decided last June, the one that overruled Roe and Casey, it pays fealty to both textualism and originalism. And it points out that the text of the Constitution nowhere mentions the right to abortion, nowhere mentions reproductive freedom. And yeah, that's true, I suppose, but the opinion fails to discuss the Ninth Amendment in any meaningful way. Now, you might remember that 2 months or so before the Dobbs decision came out in final form, the text, or most of it, pretty much all of it, was leaked to, I think it was Politico magazine. And just a couple of days ago, the Supreme Court essentially came out with a statement saying, we can't find who did it. Okay, they can't find who did it. But the leaked version of the text is interesting in what it did not say, what it didn't include. As Harvard law professor Lawrence Tribe, I think he's got to be retired now, but Professor Tribe noted in a recent issue of the New York Review of Books, he pointed out that the original leaked version of the Dobbs decision never once even mentioned the Ninth Amendment. And he also points out that the final version that came out in June of 2022 isn't much better in terms of what it says about the Ninth Amendment. Here's what Tribe writes. He says, quoting him, "The only thing the court says about the Ninth Amendment in the final opinion in Dobbs is that the, quote, abortion right is not itself founded in the Ninth Amendment's reservation of rights to the people." But Tribe goes on, that confuses the category of rights with the category of rules about how to read a text dealing with rights. The Ninth Amendment is not the foundation of any group of rights, but a directive about how constitutional decisions about rights are to be made. And Tribe finishes up by saying, searching for rights in it, that is, in the Ninth Amendment, is akin to searching for actual pieces of lumber in a manual on how to build a house. The Ninth Amendment is a rule of construction. It tells us, and it should tell the U.S. Supreme Court, how to decide cases about rights. Whenever you say something like, gee, my copy of the Constitution doesn't say anything about abortion or reproductive freedom, and so there must not be any such right that exists. When you say that, you are violating the Ninth Amendment, which says you can't do that. Now, let me tell you a story. In 1995, I was on a statewide commission on appellate court appointments. Essentially, we screened applicants on behalf of the governor for vacancies on the state Supreme Court and the state Court of Appeals. Okay, screened them, decided whom to interview, interviewed them, sent a short list to the governor. The governor would pick somebody from the list. Now, a trial judge had applied for an appellate court position, and he was invited to come in for an interview. This was a judge who had recently issued, very recently issued, a decision that had made quite a news splash. A prison inmate had filed a legal action challenging the refusal of the Department of Corrections, that's the statewide agency that administers prisons, at least the public prisons, not the private ones. The Department of Corrections had refused to allow this prisoner coffee. Now, I don't remember if that was something that was just him, like it was punishment for him personally, or it was only one particular facility, or it was DOC-wide. I don't remember. But in any event, this particular inmate wasn't getting coffee. So he filed a legal action. We call it in pro se, no lawyer. That's just this person writing something out on 8.5 by 11 paper, yellow paper, and sending it in. This particular inmate argued that denial of coffee was a denial of the Constitution. That's what he argued. The judge was the same, the judge on that case was the same judge who applied for that position on the appellate court vacancy. And he gets his case, and he looks at it, and he rules no constitutional right to coffee. He dismisses the case. Now, the judge's order causes him to be lionized in the right-wing press. Now, Fox News had not yet come into existence. That was the year after. But there were still plenty of right-wing news outlets all over the place. And they thought this was the greatest decision in the history of decisions. Bravo! What a smart judge. Put that guy on the Supreme Court, no right to coffee. That's great. Now, when the judge appeared before the commission, which was not too long after this, he appears before the commission, and he's clearly embarrassed that his decision had been turned into some political recruiting tool. That wasn't what he had in mind when he made that decision. And it's been 28 years, but I remember pretty clearly what he said about that. He said, you know, I stand by my decision. There isn't any constitutional right to coffee. But what if the Department of Corrections had denied this inmate something else? What if they denied him food? What if they denied him water? Well, there's nothing in the Constitution that says prison inmates get food or water either. But if the deprivation had amounted to those things, then my decision would have looked a lot different. So again, anytime you hear or read some argument, whether it's on somebody's podcast, whether it's in some judicial decision somewhere, anytime you encounter some argument that says a constitutional right doesn't or can't or shouldn't exist because the Constitution doesn't specifically mention it, whoever is saying that is violating the Ninth Amendment, which says you can't do that. And anytime you read or hear or encounter some argument that a certain constitutional right can't or doesn't or shouldn't exist because some group of white guys in 1788 or 1868 didn't think that that right could ever exist, well, that's kind of a close cousin of that first argument, isn't it? Rules of construction tell us what you endorse, by what you choose as your rule of construction of the Constitution. That tells the rest of us what you value, tells us what you prize, what you want to give effect to. In a very real sense, the rules of construction that you apply to the Constitution, they kind of tell us who you are. And if you endorse originalism as a rule of construction in analyzing the Constitution, then that tells the rest of us that what you value is a society in which white, cisgendered male property owners maintain power over everybody else. And not only does your preferred rule of construction tell you about yourself, it also kind of tells the rest of us who's going to win and who's going to lose in any constitutional argument using your preferred choice of rule of construction. You know, the founders and the ratifiers of the Constitution, the founders and the ratifiers of the first 10 amendments, the Bill of Rights, or subsequent amendments like the 14th Amendment, you know, they weren't perfect by any means. They probably wouldn't have claimed to be perfect, and we, looking back on them, know how imperfect they were. But they did not condemn us to a system in which the doctrine of originalism decides our constitutional arguments. They didn't do that. They wanted something better for us. How do we know that? Well, we know that because they said so. Textualism as a rule of construction is misguided when it focuses on what a text does not say, but it's really helpful when it comes to looking at what a text actually does say. Textualism can come in really handy. Before any of us will ever get to the substantive provisions of the Constitution, what we encounter first is the preamble to the Constitution. If you want to know what the founders and the ratifiers and just the average citizens in 1788 or 1789 thought about what everybody had in mind, look at what they said they had in mind. They wanted a more perfect union, and they wanted to establish justice, ensure domestic tranquility, provide for the common defense, and promote the general welfare. And to cap it off, they wanted to secure the blessings of liberty to themselves and to their posterity. And the word posterity includes a lot of people whose lives are very different from their lives back in 1787 and beyond. Liberty was supposed to be secured not only for those living in 1787, but those living in 1973 and 2022 and now. For close to 50 years, the legal and political right has used Roe as a recruiting tool. And they've taken every opportunity in the courts, in state legislatures, and in the court of public opinion to attack that decision. Now, those who may be present here, those who may be joining by Zoom, who are not part of the legal and political right, can take a page or two or three from the right-wing playbook. We should, at every available opportunity, support a right to bodily autonomy in every forum that's available to be used. Now, fortunately, there are encouraging signs. In various states this past election year, in 2022, we saw the defeat of various efforts to eliminate or restrict abortion rights. And Dobbs, however much damage it created all on its own, it still allowed and still allows, in the present tense, states to, if they choose, to recognize and protect the right of reproductive autonomy. And so efforts within particular states to protect that, whether that protection would come by way of a state constitution, because there are decisions of state courts that have recognized various rights under state constitutions which would not be recognized under the federal U.S. Constitution. And so in this past election year, we saw the defeat of efforts to restrict or eliminate abortion rights in a number of states, including some states people thought were pretty red, but they protected the right of autonomy in the form in which that right was presented to the voters. And it's also apparent that looking at the results of the elections for particular offices, there are an awful lot of candidates who won and an awful lot of other candidates who lost based on whether they supported or opposed reproductive autonomy. And those who favored protection of the right of reproductive autonomy, those candidates were doing a lot better. But it isn't just the right to bodily autonomy that's at issue. I mean, that's a big right, and that's very, very important for Americans, American women in particular, but all of us. But there are other rights that are at issue too. Justice Clarence Thomas wrote a concurring opinion. A concurring opinion is an opinion that says, well, I agree with this, but let me add some other thoughts of my own. He wrote a concurring opinion to the Dobbs majority opinion that came out in June of 2022. Thomas agreed that Roe should be overruled and agreed, yep, I agree with that reasoning in the Dobbs decision. But you know what? There are a lot of other rights that ought to be overruled, too. The right to contraception, the right to love whom you want and marry whom you want. Now, the majority in Dobbs, they were quick to point out, well, these other questions over here, these questions, they're not before us today, so we're not deciding anything. Hey, nothing to see here, folks, move right along. But, you know, let's give Justice Thomas points for intellectual consistency, because he was consistent. Rights that we now take for granted have been placed on the endangered species list. If you buy the argument in Dobbs, there are a lot of other rights that have got to be taken away too. And also, even when we're talking about the right to reproductive autonomy, there's more damage that can yet be done. As I mentioned, Dobbs doesn't prevent California or New York or Illinois or any other state from recognizing and protecting the right to reproductive autonomy. It doesn't prevent that, but that may be next. You know that the legal and judicial right wing will not rest content with what Dobbs did. Expect the right wing to push for nationwide personhood laws, which would declare that human life begins at conception. And of course, that would create a nationwide ban on abortion, as well as the morning after pill, and probably some other things as well. And keep in mind that when we're talking about anti-abortion legislation, if it's enacted, if it's enshrined into the Constitution with some personhood amendment, that affects people's lives. It would, any of those laws will, in states where they're enacted now, like Arizona maybe, and in a lot of other places, and would nationwide if that's what eventually happens, that would turn not only any abortion, but also any miscarriage or any stillbirth. That would turn those into grand jury investigations. That's what would happen. You know, as UUs, we are supposed to recognize and promote the inherent worth and dignity of every person. It's in our gray hymnal. I was reminded when I looked at this bookmark, somebody gave me a bookmark here. I looked out there to see if there were more. They weren't. Oh, well. There are more. Oh, good. Everybody should get a bookmark. Because when you look at one side, it says Unitarian Universalist Principles. It starts with the inherent worth and dignity of every person. And you know, if you have a system of forced pregnancy, which is what anti-abortion really amounts to, it's a system of forced pregnancy, then if that's what is enshrined in your law, that's in opposition to that principle of worth and dignity of each person. You know, picture, if you will, a scene. Imagine it because it's in the future, but picture it. A scene from January 22, 2073. It's 50 years from today. And there's a young woman. And she's been abused, and she's poor, and she's pregnant, and she's scared, and she's in Mississippi, or she's in Texas, or she's in Arizona. She's our posterity. She's the court's posterity. She's the founder's posterity. She's entitled to everything that the preamble to the Constitution says she's entitled to. But what she gets will depend on us.
Our closing words are written by a very favorite person of mine, Dorothy Day, social activist and journalist who was a leader in the Catholic worker movement and helped to found the Catholic Worker newspaper. Dorothy Day died 42 years ago at the age of 83, but the newspaper endures. I believe you can still subscribe to the Catholic Worker for 25 cents per year. I'm not sure about it. And if you want to read along, this reading is number 560 in the Gray Hymnal. People say, "What is the sense of our small effort?" They cannot see that we must lay one brick at a time, take one step at a time. A pebble cast into a pond causes ripples that spread in all directions. Each of our thoughts, words, and deeds is like that. No one has a right to sit down and feel hopeless. There is too much work to do. And I cannot find where she wrote this, but one of my favorite things she said was, she became a Catholic a bit later in life, but it was her anarchist friends, her communist friends, her atheist friends who thought there was only one life, who are more willing to give up their only life to make this world better.